House Judiciary Committee this Wednesday afternoon, February 4th. So we're going to hear from the Defender General on two bills, H572 that we were just talking about regarding dissemination of electronic case records, and then H566, which we took up yesterday afternoon, having to do with diversion and changing from expungement to sealing. So over to you, Matt, and whichever one you want to start with.
I'll start with the one that I have a better story about first. I'm Matt Valerio, I'm Defender General. H572, the Public Access to Court Records bill. I was appointed Defender General in summer of 2001. The first week or so that I was Defender General, I was called to testify at a committee that was, I guess, legislatively established, but chaired by Justice Dooley at the time. And it involved public access to court records that has been churning for decades at this point about what should people have access to, what should they not have access to. And my testimony at the time, this is where people anticipate your, what you're going to say. Justice Dooley did anyway. And I said, over the years, I've come 360 on this issue. And he's like, you mean 180? I'm like, no, I mean 360. First, I thought that, if it was a public record, it should be available to everybody. And then I thought, but there are people who would misuse this and, use it for purposes that were not good policy for the state, for the people who were involved in the activity, whatever. And the information would be sold, and people's lives and livelihood and futures could be damaged by this information. So we should make it difficult to get to unless you had a legitimate purpose in doing that. And this was kind of at the beginning, and I think I was a little bit prescient in my idea of what the internet was going to do. And when I said, but I've come to the feeling at this point that because of the internet in general, there really isn't anything that is secret, so to speak. And the things that are public are not necessarily accurate. So you might see things back in the day, newspapers, of course they don't exist anymore, but online or in news reports or whatever, that they wrote a story so they can sell papers and they can, get advertisers and all that stuff. And they'll keep writing stories and they'll keep changing the story as it goes along. But anybody will be able to find the story along the way. And it never really ends up being secret or protected. And your policy of trying to do that really does nothing. And so I came back to the idea that if it's a public record, the public ought to have access to it. And I will tell you that I have not had to go 360 on that when reading this bill, except for to say that my general feeling about this is that the only way we can assure that people really know what's going on in the public arena is to have them have actual access to the public records. And it should be as easy as possible, as opposed to difficult, like having to go to the courthouse to access what would otherwise be public probate records or records in a public file. And to me, that means all of it. Don't exclude criminal cases and don't exclude court orders. And, unless there is some the default should be, if it's a public record and you could access it in person, you should have it should be accessible online. That's my feeling about it. Because at least then you can say, I'm not distorting this story. I can go to the primary source material. I can read the order. I can read the filings of the attorneys. I can read, anything that is a public record in the file and get, to the extent that there's any truth, the truth, as opposed to relying on secondary sources, people's opinions about what the truth is, people's, third-hand, blogs and, Facebook posts and whatever, where people get information nowadays. 25 years ago, not all of this stuff existed. But I think I was, oddly enough, thinking far enough ahead to see where this might go. And I think I was right. And so whenever this public access to public records issue comes up, in my view, the safest way to deal with things that are actually public records is to make them easily available to the public. And that includes criminal information, and it includes court orders. There's no reason it should be difficult to go and get them. And there's no reason, honestly, where we should be requiring either court staff or anybody else to be intermediaries of that information. The more open we can be about the justice system, the less misconceptions we're going to have about it. And as you probably know, I know that people who've worked on both sides of the aisle know there are plenty of misconceptions about the justice system. If they can read the actual materials, then they can make up their own minds about what's true and not true. That having been said, when you try to protect stuff, you don't get there. So that's my feeling about that bill. And so, yeah, there are changes I would suggest in it. And the changes are primarily that you eliminate anything, like there's no reason to take criminal orders, criminal law out of nothing should be out of the mix as long as, if it's going to be available in person, if you have to go there, then it should be available online. That should be the primary default. Now, and I know there are exceptions, say in family cases for like income and asset affidavits, things that might contain whole or partial social security numbers, information that might be court ordered, but is protected medical information that might otherwise be confidential. And those kind of things you really have to look at, I think. But the default is kind of easy for me to get to. The court right now does, back when everything was paper, and it's less paper now, but you used to have a file, which was the court file, and there used to be a red file in it. And in the red file were those things that were not public, like the income and asset affidavit and the like. Long time ago, I used to sit as an acting judge when Judge Hudson or Judge McCaffrey, courthouse in Rutland's named after him, we'd go on vacation for a month in the summer, and my office was right across the street. So I'd go and I'd get these files. Oh, this is the red file, and secret red file stuff is in it, But there's a reason for that stuff. It's just, filings and orders and the like really should be available to the public, easily accessible. And the internet is the way we do it nowadays. So I would, I got that bill late this morning, so I didn't have a chance to sit down and write language for you. But if you had a policy, like a general policy idea that we ought to let people look at this stuff online, make it easy, it's easy to write. I mean, I could do it in 20 minutes to kind of fix the exceptions that were sort of baked into what's there right now.
Yeah, I mean, I think we got rid of most of that with respect to criminal files. Still, family or probate case records are not dealt with in this particular bill. And really how it's all going to work is going to be up to the court through its rulemaking process. So that's essentially how we are approaching this. We're getting rid of our bar or to the access, but respecting that how it should be done is really in the court rules process.
Yeah. I would just be pretty clear on what your policy, what the law is that they need to create rules around, because this literally is the same issue that I was talking about in August of 2001.
Right.
So that's that one.
Understood. Okay.
Any
Question for you first, I think. Do we have another bill on the wall that deals with records like these?
There are a couple bills on the wall that, or I think one might be getting introduced today, that deal with documents from either state's attorneys, but there's also, I think, H-382, which deals with a lot of record issues, but it's not the same as far as,
So
internet access.
would this bill include body cam footage from law enforcement? Or would it be one of the other ones that potentially could deal with that?
No, I don't think, unless it, well, I mean, if it's submitted and it's in the court file, then presumably it could be.
Right.
But it would have to be something filed in court. No, this doesn't go to that.
And I think that's a good thing because there's some graphic body cam footage that a lot of law enforcement agencies have that maybe shouldn't be public.
Well, it could be. I mean, if it's filed as part of a motion or something like that, as an attachment or whatever. The thing about, criminal justice system is not like a pristine place.
Right.
Like reality is not particularly attractive at times, but I'd rather have reality than have people make stuff up. But you can say what
To be totally transparent, I mean, you know what I'm talking about, but I was talking with Chris Lorsch yesterday, and his family went down in the body cam footage with that. I'm sure there could be a good debate on whether or not that should be public. So,
right. It's
and he obviously doesn't want it public, and there's he talked about a couple other incidents where families didn't want it public, but I realized family doesn't always trump what we're doing here. But
speaking of that, there might be times when you have body camera footage of incidents that the state law enforcement would not want public, that the public would want public. And I understand Chris Lorsch's issue for sure, as a family kind of thing.
Yeah.
Other folks who might be victims of law enforcement abuse might want that same footage to be available. And that's not really directly on point with this, because this would have to be something that's filed as part of a motion to suppress or referenced as part of a motion to suppress. It might be entered into evidence in the course of the suppression hearing or a motion to dismiss or the like. Now that's going to end up being in the court file. That's going to be available anyway. Once it is in the record, you don't want people guessing about at the end where somebody ends up being, a case ends up being dismissed or whatever, and they say, oh, they got off on a technicality. Well, I hate technicality because that tends to be like the actual Constitution, which is not like a technicality in my book. But if you're able to see the basis for the dismissal, then you don't have to make it up where like somebody's getting away with something. It's one of the, we don't have enough of kind of the civic education that we need to understand why these things happen in advance. So we're kind of learning along the way. The more open we can be about these things, the better, in my opinion. And of course, you're gonna have to make that decision.
Yeah.
I just wanted to, I guess like that does open a door that I hadn't even considered, which is that that means that this should also be considering like the evidence portal. Like, so I don't think, and I guess I could be corrected if it's fair. Like probably videos filed as part of an exhibit for a motion to suppress would be something the public would often want to see. And I don't think that if you access the public portal right now, you would be able to see them.
No, and my guess is if it's not entered into evidence at a proceeding, it wouldn't be public yet.
No,
But if you have your proceeding and now we've entered this piece of evidence in, and it's part of the basis for the decision and the various arguments on each side, it's part of the case that is public. So that's different than the evidence portal or the like that is where you're kind of teeing it up,
yeah.
so to speak.
But I don't think that there currently exists a singular open docket where once it has been submitted for evidence and the hearing's over, that you could access that video.
Right. Well, that might be, if it doesn't exist, I don't know that it creates an obligation for you to create one.
But if the goal, which I hear, is like we want to make this as open and public as possible.
Yeah, that's my general feeling about it.
Yeah.
I mean, so
it'd be very hard to put an axe in the, it'd be the picture, or whatever. Like physical evidence, you can't.
Yeah, but I'm thinking about like definitely like security cam footage, like so like yeah.
that presumably will come up in the rulemaking.
Yeah. Okay.
Yeah, and so we're just eliminating the prohibition here.
I have great confidence in the court administrator's ability to handle these things.
So do we. Yeah. All right, so let's move on to H5, 6, the changing expungement to sealing in the context of diversion.
The Attorney General's office has always and will continue to favor expungement over sealing for exactly the reasons that I just talked about in the prior bill, which is if it does exist as part of the record, then it should be accessible as part of the record. And one of the things that other states have had experience with is that if we are trying to say that, first of all, sealing and expungement gives the person who has had the information sealed about them, we create a legal fiction, right? We know things existed, but they can legally say they don't exist, just as though they never did exist. And we know that's all BS, right? But the question is, the difference between the two is that things that are sealed are almost by nature temporary and accessible but not allowed. Things that are expunged actually don't exist because they've been destroyed or eliminated. And where we have, when we look at like juvenile court diversion issues where a lot of things are confidential, just by nature, the only way to ensure that they don't make it into the public arena is by expungement. And our office has traditionally, and I will continue to wave that flag, support expungement over sealing. I understand there are particular instances where sealing may have benefits, but our office believes that the benefits of expungement in these types of circumstances outweigh the benefits or the issues that might arise with sealing. And so we don't support this bill.
Okay. We have questions for Matt on this?
Come on, just one. Anything? Nothing? Where's Ken?
There we go. Yeah, no.
We can stand in. I hear what you're saying and it's making me think about this a little differently. So, would, knowing that we've already passed the law that changed most things to ceiling over expungement, got rid of most expungement, would you say that what we're talking about in this bill, specifically diversion programs and everything that would qualify, again, I know
Well, this is
everything that
juvenile.
would lead to, well, there's juvenile and and then the section two is adult court diversion.
Right.
But is it,
And there may be a distinction there, to be honest, to think about. We
okay,
still would, we still would support expungement over sealing when you're balancing the two. But I would say if there would be more weight given, in my view, to juvenile expungement than to adult expungement. However, one of the things that you didn't do, and I pushed hard to make sure that this didn't go away, was expungement for deferred sentences. And, that's a hill I would stand on pretty much forever. If that remains available, and it is, I don't see why you would not do it use expungement in adult diversion cases as well, because typically expungement for deferred sentences can be for much more serious activity, more serious, than what you would see in a diversion case. So to make them akin to each other makes sense. There is, I understand the other side of this, and I understand there are some instances where expungement can cause some troubles, but little by little, the availability of expungement has been whittled away down to these very small areas at this point, and I'd hate to see it go away completely. And there's a practical reality here too, that expungement of our records is one thing, but you're never going to expunge the internet. So, I had a case that annoys me to this day, so I may as well tell you about it, where there was a guy who I represented he had multiple counts of aggravated sexual assault on a minor. And when the case was filed, it obviously hit like front page of the Rutland Herald, and other news, other news outlets and the like. He's a guy who had been a colonel in the Air Force, and his job when he was in the Air Force was to carry around nuclear codes. He was literally the dude with the briefcase shackled to his arm who would fly on Air Force One and other Air Force type things with nuclear codes. And he retired to Vermont, bought a couple of apartment buildings in Fairhaven, and got into, he had some tenants, and tenants had, one of the tenants had a kid, and when they stayed there a couple of years, they stopped paying rent. They started having some issues, and when he went to evict, shortly thereafter, allegations of the sexual misconduct came up in the course of that. And the thing that made it very kind of supportable was the graphic nature of the descriptions that the child, who was 4 years old, made, where no 3 or 4 year old would ever be able to come up with that stuff without having experienced something or seen something very graphic. During the course of an 18-month investigation, we were able to determine that the grandfather of the child had actually been molesting the kid. And during the course of a deposition, that I was taking of the grandfather, who really didn't know why he was being deposed, we started to get into this area of, and state's attorney was like, I'm stopping this deposition. This guy needs a lawyer. Like, well, I understand. And the guy who I was representing, there was actually even at the time like a no jail deal on the table. Say like, look, that very common back in those days. You get a probationary offer, you'll not no jail time as long as you do suspended treatment and you do whatever. We admit that he's like, I'm not admitting anything ever, period. Which, by the way, for most folks, they would take that deal in a heartbeat as opposed to looking at life in prison. But he was, this kind of military dude who was like, I'm not taking any deals for anything I didn't do. I don't care. I'll sit in jail as long as I need to if they end up convicting me. Well, the bottom line with this is that the case against him was dismissed. When the case was filed, it was plastered all over the front page of the paper. When the case was dismissed, it was one line in court news that said, case against, I'm not going to say the client's name, but for these two counts, brings the counts up again of what they were, right, have been dismissed with prejudice by the state. The rumor around town, of course, was that it was, Valerio did his thing again and got so-and-so off on a technicality, like the truth. And so now the guy's totally ruined. I lost touch with him. He'd probably be 100 years old now if he was still alive. In any event, you can expunge whatever you want. You can seal whatever you want. It doesn't matter in today's world because those Rutland Herald articles are always going to be there. The only way that anybody kind of has a chance, like when you're young, this kind of goes back to that other bill, where it's legitimate, you want to do the most you can do to prevent it from being a problem, because people are always going to speculate. This is where, at least in some of these cases, the availability of expungement is appropriate. And it would do, for that guy, and people didn't at that time have access to those files. So they couldn't even figure it out. Nobody really could be able to figure it out because they wouldn't, they'd never see the deposition, they'd never see the investigation, they'd never see what the state's attorney saw and what happened. So the assumptions were that, smart defense lawyer gets creepy guy off. And that's, the more we can, like, on the one hand, let the file speak for itself, the better. And on the other hand, where it's appropriate, expunge, not seal. They kind of go hand in hand. It's kind of interesting. It seems like they should be in conflict with each other, but they aren't really. So that's my story for today.
Yeah, quite an important question about the story of the bill. Was the grandfather charged?
I believe he was, and I also believe that he was not competent to stand trial. I did not, I obviously couldn't have been involved in that, but yeah, I mean, we live, the criminal justice system is a fascinating place and also a terrifying place. But it's my place. So.
Any other questions for Matt? I don't see any. Thank you so much. Do we have a schedule for anything else this week? Are we trying to drag you back in again? So, we'll look forward to seeing you and hearing about the budget next week.
Yeah, after doing it tomorrow, I'll do it better the next time.
Yeah,
And then when I get to the Senate, I'll do it even better.
you know, we're here to help everybody improve.
I appreciate your efforts.
You've fought for that. All right, thank you, Matt, and,